and I'm pleased to be chairing this webinar on behalf of the National Environmental Law Association. I start off by acknowledging the traditional owners of the land which I am on today, the Whadjuk people of the Noongar Nation, whose cultures and customs have nurtured and continue to nurture this land. I pay my respects to elders past, present and emerging. For those who may be attending a NELA webinar for the first time, NELA is a national organisation focusing on environmental law and sustainability. One of NELA's objectives is to provide a forum for and assist in the discussion of environmental law issues. It's on that basis that NELA regularly hosts webinars to explore relevant topics to matters of environmental law. Please note that we are recording this webinar. We make our recordings available to our members through our website, and your image may be captured. If you are not comfortable with this, please switch off your camera. And as always, we will leave time at the end of the session to consider any questions that you may have. And if you wish to ask a question, either raise your hand or pop the question in the chat box. So the topic of today's webinar is the making of clean energy agreements on First Nations land. The webinar will explore some of the key concepts and obligations involved in developing large-scale renewable energy projects on First Nations land, known as the Indigenous Estate, as well as setting out best practice guidelines for negotiating land access agreements with First Nations landholders. We're very fortunate to have our presenter, Dr. Lily O'Neill. Lily is a research fellow at the Centre for Aboriginal Economic Policy Research and the Energy Change Institute. She is a lawyer and a legal researcher examining agreement making and dispute resolution processes in relation to natural resources, climate change and the energy transition, environmental law and native title. Her work on Grand Challenge project, delivering zero carbon energy to the Asia Pacific, examines whether and how First Nation communities can best benefit from renewable energy generation in Northwest Australia. So I'll hand over to Lily to deliver her presentation. Thank you.
Thanks, Jess, and I hope everyone can hear me. And like Jess, I'd also like to acknowledge the traditional owners of the land on which which I sit here in Zoomland. I'm here in Northeast Victoria in the high country. This is the land of the Tungarung people, as well as just across the river, I can see it over there through my window, is the land of the Doodaroa people. And I'd like to pay my respects to their elders past and present. So saying I'm a lawyer is probably slightly misleading. Sometimes I call myself a reformed lawyer and sometimes I call myself a dormant lawyer, depending on how frustrated I am with academia at the time. In any case, my practicing certificate can be renewed at any moment, I tell myself. But yes, I am a researcher at the Australian National University. And the part of the project of the Grand Challenge project, Zero Carbon Energy for the Asia Pacific, that I am working on is the question of how to ensure First Nations people benefit from the clean energy revolution. And in this work, my team are collaborating very closely with a terrific First Nations organisation called Original Power. They're in the news today because they are launching a network called the First Nations Clean Energy Network from Alice Springs as we speak. And for those of you who read The Age or the Sydney Morning Herald, Tony McAvoy has a terrific article about them and the First Nations Clean Energy Network today. So I'm going to share my screen just very briefly so you can see this map that I'm looking at. And I'm sure you can all see that. So this is a map of the photovoltaic potential across Australia. And Australia has one of the best photovoltaic sun resources in the world. There is no geographic reason why we've just been labelled the worst fossil at COP26, but we have terrific potential for generating huge amounts of solar energy. And I don't have the relevant map for wind energy here, but also for wind energy, which I'm sure you all know, solar energy is generated during the day and then wind energy at night. And then this map here, this next map here, again, I'm sure many of you have seen this, shows the Indigenous estates, which are all the rights and interests in land that First Nations people hold communally pursuant to various different tenures, most notably the Native Title Act. And if we compare those two maps, you can see, no surprise, that the largest areas of land that have the best solar potential will be First Nations land. So First Nations people should be a very central stakeholder in the clean energy revolution, particularly of large-scale projects. I'm going to stop my share there. And so some of these very, very large projects that are currently mooted are the Asian Renewable Energy Hub in the Pilbara, 6,500 square kilometres and 26 gigawatts of wind and solar. Sun Cable in the Northern Territory, 5,000 kilometres of transmission line to supply Darwin and then Singapore, supposed to be 3.2 gigawatts. And then the most recently announced, the Western Green Energy Hub in southern Western Australia, to span across the Nullarbor over 15,000 square kilometres and a jaw-dropping 50 gigawatts of power to be generated. So these are extraordinarily large projects that are being mooted. And the two things I'd like to talk to you about today are what does a best practice clean energy land access and benefit sharing agreement look like between the companies who are developing these very large scale clean energy projects and the First Nations people who hold property rights and interests in that land. What does a best practice agreement look like? And the second point, if I get to it, who knows, what conditions are conducive to First Nations communities fairly sharing in the costs and benefits of these large scale clean energy projects? How do you know when you're starting one of these clean energy projects, looking at the community, whether they're going to benefit or not? So hopefully I'll be able to talk you through some of what the research says about those two questions. Okay, so we at the ANU have just put out a best practice guide. It's called Clean Energy Agreement Making on First Nations Land. What do strong agreements contain? And I'll send this around to the organisers of this seminar for those of you who are interested in going through our best practice guide. We published it a couple of months ago. And in this best practice guide, we have a forward from Karina Nolan, Yorta woman, who's the CEO of Original Power, the organisation I was just talking about, who are launching the First Nations Clean Energy Network today in Alice Springs. And in that forward, she really captures some of the conundrums in this area. So she says that First Nations people need to treat the crisis of climate change as an opportunity to be part of the economic transition to clean and sustainable energies. She points out that First Nations people have been critical to sustaining country and know how to best manage lands that could host these very large-scale renewable energy resources. And she also makes the point that many First Nations communities want to engage with renewable energy as it's cleaner and much more sustainable for country. But, and here's the kicker, she says, when it comes to large-scale projects, we can't just assume that these will inherently benefit communities. And she's completely right. And very unfortunately, we'll start out with the bad news first. What the research shows when looking at low carbon transitions, there was a very substantial piece of research that came out this year that looked at 20 years of low carbon transition climate mitigation projects across the world, from Africa to Asia, Europe to North America, across clean energy projects as diverse as wind energy, hydroelectric dams, electric vehicles, household solar panels, et cetera, et cetera. And it said across 20 years of these projects, across all these diverse range of methods of delivering low carbon transitions, that these projects that deliver climate mitigation also create a fulcrum for elitism, discrimination, and the consolidation of wealth. So as Karina pointed out, we can't just assume that because these projects are clean energy or green energy, that they will necessarily benefit the First Nations owners of the land on which they are situated. Now to how can we ensure that they do benefit the First Nations landowners? Well, our best practice guide is divided up into several different sections, and I'm just going to take you through a few of those. One is looking at the best practice during the negotiation period, what we academics call the agreement making period. I'd be very interested to know, there's a few lawyers here I know who are native title lawyers. I would be very interested to know what you call it. And so during that negotiation period, one of the key concepts behind a best practice model is to ensure that First Nations people are resourced properly to obtain qualified, independent legal, scientific, business, accounting, and other advice for the negotiation. And then that funding is not tightly tied. I know of many a negotiation in which funding for the lawyer for the second meeting was would only be provided once the first meeting had been concluded. So it's very dependent on the company goodwill for the traditional owner group to be able to pay for their lawyer for the next meeting. Another principle, a best practice principle during the negotiation period, is that the agenda, nature and timeline of the negotiation are not just determined by the company. That it's not the company that says this is how the negotiation will go. I've spoken to many company representatives in the resource extraction industry who swear black and blue that in the Native Title Act, it says that a Section 31 negotiation is comprised of 4 meetings. And at meeting number 1, you do this, meeting number 2, you do that, etc. This was a widespread belief that I came across. So best practice is saying that the agenda, nature and timelines of the negotiation are developed between the community and the company, and that the community get to also set these things in place. Another best practice principle for the negotiation is that the agreement benefits should be based on a sharing the benefit methodology, that First Nations people are not just another box to tick. They are integral stakeholders in the project, and they will be bearing a huge amount of the costs of the project because the project is going on their land, and so that therefore they should be sharing in the benefits of the project as well. Also, best practice principle in relation to the company is that there should be a whole of company commitment to these principles, particularly company leadership. And we've certainly seen that come out in the Juukan Gorge inquiry, that Rio Tinto used to be a real leader in this area, and there was real company leadership commitment to ensuring best practice principles engagement with Aboriginal traditional owners, and that when things started to go wrong at Rio Tinto, it was when that company leadership stopped paying attention to these things and stopped believing that they were important. Lastly, in fact, there's more principles in the guide should you choose to read it. But lastly, for the purposes of today, but by no means leastly, is adhering to the standard of free, prior and informed consent, which I don't think I need to go into, but essentially the traditional owners, native title holders, First Nations landowners need to be able to say no to the project. And of course, the ability to say no to a project means that if they do want to say yes to the project, benefits are likely to be greater if you're just thinking about any kind of negotiation you've been to. So what does a best practice agreement look like? And again, I'm not going to go through it all. You can read it all in our guide, and particularly the lawyers amongst you, I'd be very, very interested if you have a read of what we've written for any feedback. Would very much appreciate that. What we've done is we've taken some research, some very significant research from Professor Kieran O'Farquharry, who studied about 40 or so land access and benefit sharing agreements from the mineral extraction industry, and set out what he found was the best and worst of agreement clauses across the usual criteria: environmental protection, cultural heritage protection, jobs, business development, financial payments, implementation, etc., etc. And as all of you listening, I'm sure will know, the big problem with studying these agreements is that they are usually private and confidential. There's a few agreements that aren't. For those of you in Western Australia, the Browse LNG agreements were publicly available. They were a rarity. So understanding what's in these agreements is very, very hard for anyone who's not a native title lawyer. And again, for those of you who are native title lawyers, I'm sure you have template agreements that you bring out, you know what goes in the agreements, but nobody else does. So Kieran O'Facully, going through these agreements that he was given access to on a confidential basis, established a scoring system so that someone like yourselves could go through an agreement and give it a score about whether it was a strong agreement or a weak agreement. And in our best practice guide, we've set those out, and we've also added in a column to say how we think it might be altered for clean energy agreement making. So I'm not going to go through it clause by clause, but I'd like to draw your attention to just a few of those. So in terms of cultural heritage protection, which is clearly a subject that has been very much front of mind for everybody, again, since Juukan Gorge and again, since the parliamentary inquiry has come out. So what Kieran says about a strong clause for cultural heritage protection. A strong clause would give a very high level of protection. It would stipulate that a company has to avoid all damage to cultural sites without exception, and that First Nations landholders could be funded to do cultural heritage protection work, can choose which technical staff to work on cultural heritage issues, and ensure ongoing cultural competency training for company personnel. And that these clauses should be embedded in the agreement, including perhaps by way of a power of veto in certain circumstances over, say, a cultural heritage protection committee or some such. A very weak clause would be to simply comply with weak cultural heritage legislation laws that allow cultural sites to be destroyed and prohibit First Nations landholders from objecting to cultural heritage matters under the relevant legislation, which is, again, of course, what we've since found out was in the agreement with the PKKP people and Rio Tinto was the clause about cultural heritage simply referred to the very weak Western Australian cultural heritage legislation and prevented signatories, native title holders, from objecting to the destroying of cultural heritage sites. So very weak clause. In relation to implementation of the agreement, also very important, a strong clause would set aside personnel and significant financing specifically for the task of implementing the agreement, would ensure structures, processes and financing are set up for the purposes of implementation, would require senior decision makers in the company to focus on implementation and review of the project, would provide incentives to company personnel for environmental protection, cultural heritage, etc., etc., etc. And a weak clause would not really make any mention of implementation nor set aside any funds. So please have a look at those. Again, for the lawyers amongst you, I would love feedback on what you're seeing in these sorts of agreements. And I would also really like if there's to be some discussion today about a proposal that we have in the guide. And that proposal in the guide is that we say that it may become prudent for companies and First Nations native title holders to obtain an independent assessment of how an agreement compares to these provisions. So you negotiate an agreement and, you know, you get your native title lawyer from Mallison's to an independent lawyer to provide potentially investors, potentially the community, potentially the company, an assessment for whether this guide is a strong guide or a weak guide. And that way we say, and we're developing this proposal a little bit further, but again, I would love some discussion on this. We think that that might be a way of ensuring that the agreement stays confidential, but also being able to have some sort of way of independently verifying the agreement so that it's not just up to the company to say, this is a fabulous agreement, it's a best practice agreement, without someone being able to, you know, look at it and, you know, have an independent person say whether that's the case or not. And that this also may help the First Nations community know whether they're signing up to a good agreement or not, but also, you know, raise the bar. Once you shine a little bit of sunlight on these agreements, I think that might have, it might result in raising the bar for these agreements. Now, secondly, and I'm assuming I've got time, Jess, the second question I'd like to look at, and look, let me stop there. Are there any questions? Does anyone have any questions at this stage before I delve into the second topic of today's talk, for which I have a block of chocolate for a pop quiz at the end? Any questions so far? No, shall I carry on?
Yeah, I think so. Perhaps I'll collate the questions for the end,
Okay.
and we can. Oh, sorry, I do have a question that's just come through, which is, do you know of any agreements, or
how many agreements have been concluded to date? I don't off the top of my head. I did check the Native Title Tribunal recently. It's not a huge amount. I mean, and look, I haven't seen any text of these agreements. I know that they are. The short answer is, for those large-scale projects, I don't think they had concluded any agreements yet. And there'll be some people on the Zoom who could answer this question better. But when you put in words like wind, solar, etc., farm to the Native Title Tribunal's website, off the top of my head, it's under 20. And I don't know the scale of these sites because the information is very rare. We are at the ANU next year going to embark on a research project where we try and find out far more information about what's actually going on in these agreements. And if I come knocking on your door for information, anybody here, I'd really encourage you to participate.
And Lily, do you know of any agreements for extractive industries that were independently verified?
No.
Was that a common practice? No.
No. It's a new proposal from us as to how it might be done. I do know that it's done informally during negotiation processes. And in fact, that's why these guidelines were developed by Professor O'Farquharry, was to be able to give traditional owners during the negotiation process some sort of independent way that they could gauge things. So I'm sure it's done on an unofficial basis during the negotiation process by native title lawyers sometimes. How often it's done, I don't know. Again, I would love to hear from any native title lawyers about whether they've ever done it.
Mm-hmm.
Now, should I answer this? So,
yeah, if you could.
So next question, thanks. Is it Will Dilly? How can states incorporate the best practice guidelines into EIA processes? Oh, terrific question. So many ways. Look, there's essentially, I mean, you could change the legislation, but setting that aside, there's so many points in different approval processes. If you think about a large project and all the approval processes that are needed, under the land tenure arrangements, I could go on and on, and how many points in which the relevant decision maker has discretion to take various things into account. There could be multiple ways in which a government could institute a policy to say, we expect these agreements to be, to rate a 20 out of 24 or whatever. I'm just making that number's made up totally off the top of my head, but there's any amount of points along a decision maker's discretionary processes in granting approvals in which these sorts of things could be inserted, we think. Yeah. All right. You're all just hanging out for the chocolate bar. All right. Okay. So the next thing I'd like to talk about very briefly again is how do you know if the community you're going into is going to be benefiting from a project? And the research, again, this is from the mineral extraction agreement making. The research says that there's 4 conditions that are influential in whether it's a strong agreement or not at the end of the negotiation process. The first of these is the political strategic power of the community. The second is their legal rights, the strength of their legal rights. The third is the ethos of the company involved. Wayne Bergman once told me that he thinks if the CEO is over 60, they'll be thinking about their legacy and are far more likely to sign up to a beneficial agreement. And the fourth, sometimes influential, sometimes not, is how profitable the project will be. And what the research says currently anyway about the most influential of these factors is that the political strategic power of the community plays the largest role in whether they will be able to negotiate a strong agreement or not. And the chocolate game involves two case studies I'm going to talk you through, and I've got a pop quiz at the end. So I just wanted to illustrate what kind of difference this can make to a negotiated agreement. So both these case studies I'm going to talk you through are for very similar projects in size, same resource, same timeline, different sides of the country. And I just wanted to talk you through the political strategic power of the respective traditional owners, native title holders in each of these cases. So case study one, we're represented by a major land council. They were acknowledged by many government public servants as a fearsome negotiation opponent. One company representative, who was formerly a bureaucrat, said, if you think you can go into that area with that land council at your throat, who are you kidding? They received very significant funds, this land council, for the negotiation, both prior to and during the negotiations. This funding could be used pretty much at the land council's discretion and was not conditional on certain negotiation milestones, which obviously I spoke about before as being best practice. The CEO of the land council could often call the Premier directly. And for those of you in Western Australia, I'm sure you're guessing what this was. The state government was a party to all negotiations and represented by very high level public servants. And the Land Council was able to forge very important alliances with unions, churches, and other civil society organisations. And this whole process garnered very, very significant media attention, including from international media outlets like the New York Times. So that's case study one. Case study two, the native title holders' previous land council was deregistered, and then these native title holders were represented in the negotiations by several different law firms, not their regional native title body. They were funded by the companies for only a very limited amount of time. They didn't have any funding for scientific environmental accounting advice. They didn't have any access to top politicians or public servants. The Deputy Premier at the time had no idea what was in any of these agreements, even though he was across what was going into similar coal seam gas agreements for farmers. And there was almost no media attention on these Indigenous land use agreements, in spite of native title holders trying to get media attention, including by burning an effigy of a company representative in the middle of the CBD. So I think obviously the answer is case study one received a higher agreement in terms of financial payments only, but also in relation to other aspects. But what I'd really like, let's make this interactive. I would like you to vote about how much more you think the native title holders in case study one received in terms of times 2, times 4, etc. How much more? And that's who the block of chocolate is going to. And I will send it to you. I'll put it in the post. So can we have a minute where everyone would like to vote on how much more you think case study one native title holders got, bearing in mind these are similar projects, same time, same resource, very similar. James, thanks. Jess, thanks. Ross, thanks. Anyone else? It's linked 70%. Yeah, great. Tess, Fiona, fabulous. 20. Arabella, thanks. Sophia, yep. Great. Andre, thank you. Anyone else? Simon, thank you. All right, Jess, what do you think? Oh no, got a few more. Mirinda, thank you. Anyone else? Okay, I'm going to take that as going, gone. Okay, Jess and Sophia, 100 times. Congratulations. I'll have to buy another block of chocolate. Please, can you email me your postal address?
I'll put your email in the chat. You can hold you to it.
Sophia, would you like to say anything about that? About why you thought it would be 100 times? Would anyone like to comment? Would any native title lawyers like to comment, please? I'd be very interested. No? Okay. So you can see that this idea, and there is sort of an implicit idea that the clean energy revolution will be one that if you're green, you're also potentially socially justice minded and, forging ahead with First Nations people's rights, et cetera, et cetera. And this is research that comes from the extractive industry, but I'm sure for many of you lawyers, again, who are out there, you will be the same people who will have been negotiating the extractive industry agreements as will be negotiating the clean energy agreements. These things are path dependent. What happened before is likely what will happen again, maybe. But you can see that a community is likely going to be paid more where they are more politically connected and more politically powerful. And, what does the research show about, what can a community do to increase their political strategic influence? All the sorts of things that you'd think, forming alliances with local international environmental organisations, engaging in investor activism, including shareholder activism, invoking international instruments like free, prior and informed consent, and local, national and international media attention. Which brings me back to Original Power and the First Nations Clean Energy Network, which again is being launched today. And they are launching this First Nations Clean Energy Network with a view to influencing First Nations people's political and strategic influence. And they've certainly got some very significant attention and some very significant people involved. And I think this is a really interesting space to watch. I'd also like to finish off with a little anecdote, which again, I would love some input from at the end if anyone's interested. So I and some colleagues wrote an article in The Conversation in the middle of last year about native title rights in relation to renewable energy projects. And the editor of The Conversation put the article, the title of the article, something like why First Nations people have few rights in relation to clean energy projects. And I was discussing this issue later with a native title lawyer that I know, and he said that he disagreed with the view that these projects could be pushed through in the approval sense pursuant to Section 24KA of the Native Title Act, that in fact there were no avenues in the Native Title Act to validate these projects without an agreement with the native title holders, that therefore an Indigenous land use agreement was needed to validate these projects, and that therefore doesn't that start to look a lot like a veto right? I'll leave you with that thought, and back again to the 4 factors that make a difference in terms of these agreements. The most influential at the moment being political strategic influence, but the second being legal rights. And if indeed this view of the Native Title Act is correct, that there is not an ability to push through the approvals process without compulsory acquisition and without an agreement, that this begins to smell a lot like a veto right. I'll leave it there, and I really hope for some questions. Sophia, thank you. Just a guess. Good guess. Jess?
Thanks so much, Lily. I will open it up to questions now. So if anyone has any questions for Lily, either raise your hand using the little buttons down the bottom of the screen, or pop the question in the chat and I will put it to Lily. But perhaps I'll sneak in and ask a question before anyone else. That I think my main question is, given the current I guess urgency to move towards renewable energy, especially off the back of COP26 and all of the certainly investor pressure that companies are facing, do you see that there's a risk that these agreements might be rushed? Those companies hoping to start renewable energy projects might beat competition or take advantage of the current political and investor climate. And if there is a risk that those projects are getting rushed, how can that risk be managed in terms of these agreements?
Yeah, thanks, Jess. It's a really good question. And the short answer is that, let me go back a step. So, we've been engaging in my project at the ANU with, say, the Clean Energy Council, and some of the people, the representatives of companies on the Clean Energy Council are terrific people. And I'm thinking about people like Luke Blackburn, who works for Yarra in the Pilbara, or his name slips my mind, apologies, Beyond Energy, Justin Coburn from Beyond Energy. And they are at the forefront of trying to ensure that these projects make a difference in the lives of the First Nations communities that they're operating in. And the types of initiatives that they're coming out with in relation to employment, in relation to ownership, are absolutely laudable and totally fantastic. But they're the first to say that the clean energy industry, like any industry, has cowboys in it. Of course they do. And I think that certainly a lot of the feedback we often get from these company representatives is that, it's really hard to engage with First Nations communities. That's often what people say. And I always think that, look, all communities are hard to engage, is my view. I think the hardest community I've ever engaged with was when I was the president of the Collingwood Children's Farm Community of Management, which is an inner city farm in Melbourne, and we had a garden plot for locals who grew vegetables, and I've never dealt with a more intractable community as the owners of owners. They weren't owners, they thought them, because they used to will their garden plot to their children, and we'd say, no, you don't own it. Anyway, so I think that's a bit of a myth, but it is a persistent myth that has to be dealt with, that First Nations communities are somehow more difficult and more intractable to deal with than others. And so therefore that companies might try and farm it off to, say, a specialist, contract company specialist, rather than taking it on themselves. And I think it's so important to take it on yourself as a company and to have ownership from it from the top. So short answer is yes, Jess, of course, there will always be companies that are trying to rush these things through. And it doesn't have to be because they're doing it for nefarious reasons. It could just be because I think it's, in the too hard basket. But yes, it is a fear, and I know that that's why, say, the work that Original Power are doing is so important, because what they're trying to do is be on the front foot, so they are seen as a key stakeholder rather than a box that needs to be ticked in the approval process down the line. Yeah. Thank you. Yeah.
Okay. So I've got a question from Hannah, which is that some solar projects in Rajasthan, India, are extraordinarily large. Is your project working with lawyers in India on equitable agreements?
Fantastic question, Hannah. No, but I would love to know if anyone knows. So look, sorry, let me go back a step. Terrific question. I would love that. As a researcher, getting access to information is always the hardest thing, and getting access to agreements is always the hardest thing. In my PhD, which looked at resource extraction agreements, it wasn't until year 4, when I'd been harassing people for a very long time, that people start giving you things and start telling you things about it. So for the lawyers amongst you, you know what goes into these agreements, you know what's happening. I would implore you all to engage with research in a very confidential manner, in which legal client privilege can be maintained, et cetera, so that more is understood about what's going into these agreements. But Hannah, if you know anyone in India who's negotiating these agreements, I would love a hookup.
Great. And we've got a question from James here, which says, given Australia's push with solar rebates for home ownership, is there much demand for large-scale solar companies seeking vast areas of Northern Territory land for solar farms?
Good question, James. And look, there might be people on the call who know far more about this than I do. There probably are. But I think the target market for these large scale solar farms is, well, I mean, Sun Cable is looking to power parts of Darwin and Singapore. The Asian Renewable Energy Hub is looking to power a huge amounts of industry in the Pilbara. So it's sort of industrial uses and industrial scale. They're calling it wind and solar at oil and gas scale. There's also a lot of downstream uses for renewable energy in terms of green hydrogen and green ammonia. So potentially some of the people will be the same who are putting solar panels on their roofs as are receiving power from these large scale projects, but it's a much wider target of people. And I think that large scale solar near industry has real potential because you don't have transmission issues for the electricity. Again, I'm a lawyer, I'm married to an engineer. If he were here, he'd be rolling his eyes at my explanation of that. But anyway.
I did have also a question around the confidentiality aspect of these agreements. Do you think that the confidentiality aspect of the agreements serves a purpose for the native title owners, or is it more for the benefit of the energy companies?
Look, my very personal view is no, it doesn't serve the native title holders. I think that you can make these agreements public, and if the native title holders, for example, don't want the exact amount of money that they're receiving to be widely known, to just, redact that bit. I think that when you talk to people in industry, people in industry who are negotiating these agreements, they know what their competitors are paying in these agreements. It's industry gossip, but the traditional owners don't know. And I think, it's like when you're buying a house and you go onto realestate.com and you see what the prices that are being paid for your suburb are, which, as we all know, have gone up astronomically during the pandemic. You need to know what the baseline is and what other people are being paid. And there's a real information deficit, in my view, between what companies know is being paid and is being done in all those other areas in relation to employment, cultural heritage, etc., and what traditional owners might know. Now, of course, if it's a very big land council like the Northern Land Council or the Kimberley Land Council, they've got real industrial memory, organisational memory, institutional memory about what's going into these agreements. So you wouldn't put them in that bucket and you'd say that they know very well what's going on in these agreements. But I think some sunlight onto these agreements, I think, would be a good thing, is my view.
Great. A few more questions coming through. So one from Ellen. Are there many projects where traditional owners have an ownership stake in projects or ongoing involvement with management of the project?
That's an excellent question, Ellen. And again, the short answer is I don't know for certain because I haven't seen any of these agreements, but I've certainly read publicity about these agreements, and the very, very large 50 gigawatt project in southern Western Australia says that there will be, quote, carried equity was in the press release for traditional owners in the project, and that traditional owners will have, native title holders will have a board seat. What that means in practice, I don't know, but it certainly sounds like a really positive development. And I've also seen a TED talk from Brendan Hammond, who's now involved, who obviously has a very good reputation in this area. He was with Argyle Diamond Mines for Rio Tinto when they were doing very good things in their agreement making. A TED talk where he talked about what the Asian Renewable Energy Hub were hoping to do with native title holders in the Pilbara. So, but again, so what's being said publicly in media releases, company documents, etc., is very positive, and it does look like these clean energy agreement making agreements may be an improvement on what has potentially gone before sometimes in the mineral extraction industry. But again, we're lawyers here, right? Show us the agreement, show us the fine print.
Yeah, I've got a comment from Robin here, which said native title holders want financial provisions kept confidential. In her experience, that said native title holders do talk to each other and can be members of different groups that overlap or are adjacent. Yeah,
thanks. Yeah, you're totally right about that, Robin. And look, just a comment too about neighbouring groups, which is, we do see that there may be potential because renewable energy it's a widely dispersed resource. It's not like the bauxite is at X spot, you may be able to, you don't have to go to a specific native title group to dig up the particular bauxite that's at that spot. Rather, this whole area has really good solar resources. We do see the potential for companies to maybe be able to pick and choose the land that they are generating electricity from solar or wind. And in a way, picking the land that might be easier. So if a company might see a particular group, native title group, as being difficult to deal with, there is a real possibility for clean energy companies to simply go to the neighbouring group or potentially pick a pastoral lease instead, for example. So we do see that as a danger.
Is there any other questions that anyone has? I did... Perhaps one further thought I have in relation to the confidentiality aspect is whether companies might be more willing to share the certain aspects of the agreement, perhaps particularly in relation to cultural heritage, and make those aspects of the agreement public, at least not necessarily to the entire public, maybe just to their shareholders, but to really show how they're delivering on the obligations and meeting the pressure that shareholders are delivering.
Yeah, look, absolutely, Jess. And, again, we saw after Juukan Gorge that it was the institutional shareholders, the super funds, who were demanding accountability. And I think probably the days are gone where a company could just say to shareholders, you have to trust us, we're doing the right thing, because that's what Rio Tinto did, and they were doing the right thing for a long amount of time, and then they weren't and nobody noticed. Well, the traditional owners definitely noticed, but the investors didn't notice until something catastrophic went wrong.
Yeah. Great. I've got a question from Marinda that's just come through, which is, has there been any research done on the general opportunities for coexistence of renewable or hydrogen projects with traditional use rights? For example, Western Australia will soon reform the Land Administration Act to allow easier access to pastoral leases. And is there the potential for coexistence with pastoral activities? She wonders if much thought has been given to general impacts on and coexistence with native title land use, commercial uses aside.
Yeah, look, Marinda, excellent question. And I'll start by answering that I'm in no way an expert in what these projects look like. Certainly, there is always talk at conferences that large-scale projects that allow sheep to graze underneath or have people, have some sort of other use of the land are to be preferred, and that, say, where a solar array covers the land completely, that can have detrimental impacts on the land. But again, I'm, a mere lawyer, I don't know. I am currently awaiting on, I'm writing an article with a colleague of mine who's a hydrogen expert. It will be out in the environmental review shortly, where she will explain from a hydrogen expert perspective what these projects look like and what these will look like for native title holders. So I'll be able to explain more, but my very basic understanding is that it's an industrial precinct where you produce hydrogen, and that obviously there's a lot of talk about green hydrogen that is produced from electrolyzed from renewable energy electricity rather than from other methods that are carbon intensive. So, but terrific question, Marinda, and I've enlisted my hydrogen colleague to help me answer that question.
And I've got a comment here from Robin, which is that she thinks the real issue with WA is that so much land is open for mining, and the difficulty for native title holders and renewable companies is that once the land has a tenement over it, it's tricky to get rid of it.
Yeah, absolutely, Robin. Yeah, are these all just land grabs, these massive projects? Who knows? Will anything ever be built? Excellent question. And it sounds like you've got a fair bit of insight. And if you'd like to talk to me about it later, I would very much welcome you.
We've got time for one more question, I think. So if anyone has one, pop it through. perhaps I did have one question in relation to the
Sorry,
financial.
Miranda, thank you for your comment too, as well. If you'd like to give me any insights into what's going on, I would also appreciate that.
Yeah, so just a quick question in relation to the financial payments. I think the paper, when you look at the extractive industries, there's a role for Indigenous or traditional owners to become involved in aspects of the project throughout its life cycle, but more with renewable energy, the intensity is really at the start of the project. So
yeah.
Are we going to be seeing more pressure in these agreements to make the financial incentives larger at the start, given that there's not going to be that necessarily that flow through the life of the project?
That's a really interesting question, Jess. I don't know the answer to that. I'd be really interested. So we certainly sent our guide was certainly sent through many people at the Clean Energy Corporation who added their thoughts about this, but the specifics of how and when payments will be made and what form they take, etc., is I don't know, but it's a very astute observation from you that they may well be different because of the nature of the project is very different. Yep.
Great. All right. Does anyone have any further comments or questions before we end the webinar? If not, I have put Lily's email address in the chat earlier, so you could, Lily, if you're okay with that, people could send through their thoughts.
Yeah, and Sophia, if you do want to send me your address, I really will send you the block of chocolate. Jess, you too.
And yeah, also we will be circulating by email the recording of the webinar, some material, especially your paper, and perhaps Lily, if you could keep us up to date on that upcoming article on hydrogen specifically, we can circulate that as well to the attendees. Yeah, but otherwise, thank you so much for making yourself available today and exploring this really interesting and important topic. We really appreciate it, and yeah, thanks everyone for joining us, and I will end it there.
Terrific. Thank you so much. Thanks, everybody.
Bye. Thanks, Lily.